often referred to as the global epicenter, is a vibrant and bustling city that never sleeps. It's a heaven for immigrants, warmly embracing people from all walks of life. Following its branches in Washington, D.C., Atlanta, Los Angeles, and Dhaka, Rajoula has expanded to its fifth location, now serving clients in the heart of New York's bustling Forest Hill Tower in Queens. With 7 attorneys and more than 100 law clerks and case managers, Rajoula is one of America's largest immigration law firms. From us, you'll get all types of employment and family-based, asylum, refugee, and legal immigration-related services from any part of the world, including EB1, EB2 NIW, EB3. Rajoula is your safe address for accurate and reliable immigration services in the shortest possible time. Contact the number shown on the screen today.
Hello viewers, and welcome back to the weekly live session held by Rajoula. For today's session, I am your host Isabella, and with me we have Mr. Raju Mahajan, who is going to be giving his enlightening speech for all of you today. Before we move on to that segment, a small announcement for all of the viewers, and that is that from now on, the weekly live session will be held on Mondays at the same time. We look forward to having all of you join us in these sessions. And thank you so much for joining us, all of our spectators. Now, without any further ado, let me welcome Mr. Raju Mahajan, our principal and founding attorney here at Rajoula. Mr. Mahajan, how are you doing?
I'm good. Thank you very much. I'm a little under the weather, but it's okay. This cold here. And by the way, Happy New Year to you and Happy New Year to all of our audiences right now.
Yes. Thank you so much, Mr. Mahajan, and Happy New Year to everybody. Hoping we all start the new year with new energy and happiness. Now, for today's topic, we have a very important subject to discuss. The subject for today's live session is Temporary Workers Visa H2A and H2B. Mr. Mahajan, what do you think about this?
Thank you very much. Actually, initially I thought I'll cover both H2A and H2B today, but then I discovered that both of the topics are too big. So today we are only going to talk about H2A. And in our next Monday session, we're going to talk about H2B, even though both subjects are very similar, very common, but I decided to give extra emphasis to both of those. So we're going to have 2 different sessions. So today we're only going to talk about H2A. Can I see the PowerPoint? Okay, thank you very much. Yes, so as I said, by the way, thank you very much, Isabella, for introducing me. So our today's topic is H2A, Temporary Agricultural Workers. Next slide, please. So, before I talk about this, so under this visa, American farmers, they can bring foreign workers to work as a temporary worker. And this is a very good opportunity for foreign people to come to America and have a job in agricultural sector. So those who have agriculture background, this is a very good opportunity for you. So the first question is, what are the preconditions for the petitioners? The petitioners means farmers, or the employer who are going to employ you in the farm or any other company, agriculture-related company. They're the petitioners. So what are the requirements? So to qualify for H2A program, the petitioner must either be a U.S. employer, a U.S. agent, or a member of a U.S. organization of agricultural producers who is also listed as a joint employer. So these are a legal legal discussion, but in short, if you are a farm owner, if you are a farmer, if you're an agent, you can employ people from foreign country to work in American farms. Next slide, please. All right. So to submit a non-immigrant worker, and this is the continuation of previous topic. So to submit a non-immigrant worker petition with USCIS, the petitioner must, these are the recommendation, demonstrate that hiring an H2A employee will not have a negative impact on the working condition or wage of US workers in a similar field. meaning that they need to establish that bringing this foreign labor is not going to have any negative impact on the local community's work environment. Then show that the petition could not be filed. The position could not be filled by a qualified U.S. worker who is also available, willing, and able to perform the required job. Again, what it means is that the farmer is not finding qualified people in the local community. That's why he or she is bringing foreign labor to the America. Attach a valid temporary labor certification. Of course, we are going to talk about that later. Provided by U.S. Department of Labor to your H2A petition, except it emergent circumstances. Sorry, I'm a little under the weather today, as I said. Sorry for the interruption. Also, offer the beneficiary a seasonal or temporary jobs. This cannot be a permanent job. This is a seasonal or temporary job. That's all. This is the very crucial topic of our today's discussion. The entire thing is for seasonal or temporary job. Next slide, please. All right. To obtain the required temporary labor certification, employer must satisfy the following eligibility criteria. Must be an employer with a valid federal employer identification number, FEIN number. All businesses here in America has FEIN number, and a company that is physically present in the United States. This is very important. A lot of people, they ask me question, hey, I have a company in a foreign country. Can I bring people to America? The answer is no. If your company is physically located in a foreign country, you cannot bring worker here. Also, must be seeking to fill roles that are agricultural in nature. So this agricultural in nature is also a very controversial / subject to interpretation kind of topic. I'm not going that detail about this. If anybody has any specific questions, please reach out to me. I will see if your employment is agricultural in nature or not. But in general, it must be related to agriculture. Must be looking to fill a full-time position. So this is a full-time. It's a temporary job. It's not a permanent job, but it must be a full-time job. It cannot be a part-time job. Next slide, please. All right. So this is the precondition for the employee or beneficiary. So previously we talked about what are the preconditions for the employer. Now we are going to talk about precondition for the employee or beneficiary. The prospective employee must be a national of a country found on the eligibility country list, which is updated periodically on the Federal Register. So to be qualified as a employee, as a beneficiary of H2A, there is a list of the countries, and US government, they update this list every year. So you have to check whether your country is listed in that list or not. If you are not, you can still come to America. That's our second topic we're going to talk. However, it's way easier if your country is listed as one of those enlisted countries. Next point is, not slide, sorry, go back, yeah. Countries remain eligible for 1 year after the list is published. Employers may, in certain cases, hire workers from ineligible countries, but in that case, the petitioner will need to provide more evidence with their Form I-129. All it means is, even if your country is not listed in that list, you can still come to America. In that case, the employer needs to provide some more information, more evidence, and which is not very tough. We can help the employer. So short answer, yes. Even if your country is not listed as one of those countries, you can still come to America. Now, next slide, please. All right, dependents of H2A. So the spouse and children under the age of 21 are qualified as dependents, and they can come to America under this visa. Next slide, please. Cost. So this is a lot of time people ask question about cost. So for the temporary labor certification, the Labor Department charges a $100 application fee and $10 per certified H2A worker. So all it means is, let's say the company, let's say that the name of the company is ABC Agricultural Corporation. They are going to file one LC, one labor certification for that, and for 15 beneficiaries. So one LC for 15 beneficiaries. So all they have to pay is $100 for the LC and $10 per beneficiary, meaning $150 for 15 beneficiaries. So the total would be $1,600 to USCIS. Then to file the Form I-129, the US employer will need to pay a $460 filing fee. The prospective employee, for their part, will need to pay a fee for their non-immigrant visa application if they are living outside of the country. So first, the employee already paid like $1,600 in our example, and then they also need to file $460 for I-129 form. Then when the beneficiary is coming to America, let's say the beneficiary is living in a foreign country, they also have to pay for the visa fee, embassy fee and other things. So they must bear that cost. Also note that premium processing is available for I-129, which takes the USCIS to give the decision within 15 days, and it costs $1,500. So this $1,500 is addition to the $460 filing fee for I-129. A lot of time people ask me question, hey, if I apply for premium processing, do I still have to pay $460? The answer is yes. The $460 is the filing fee, and $1,500 is the premium processing fee, not the filing fee. In total, it would be how much? Like $1,960 kind of thing. Next slide, please. All right, steps for H2A application. So, there are three steps. The first one is petitioner applies for a temporary labor certification with the Labor Department. In short, we call it DOL, Department of Labor. Once it is approved, petitioner files Form I-129 with USCIS. Once it is approved, and then if worker is living in a foreign country, they apply for non-immigrant visa. They face the visa interview in their local US embassy, and then they come to America. However, if the person is already in America, they don't need to face any visa application in embassy or anything. Or there are some countries, they don't need visa to come to America. They can just directly cross the border with this approved H2A visa, H2A application, and they can come to America. So it depends on your circumstance, whether there's a third step or not. So this is the three steps for H2A application. Next slide, please. So the first step, apply for temporary labor certification. Let me go a little detail about this. So first, the employer, the petitioner needs to file Form ETA 790/790A between 60 and 75 days prior to the first day of work. So let's say the employer intends you to start working in January 1 of a certain year. So they must submit this Form ETA 790/790A within 60 to 75 days prior to January 1, because it takes some time to get it approved, get the visa and other things. So they must take have enough time in their hand before they can apply for you. Then a cover letter attached to the job order application is stating that the employer intends to file petition for H2A status, of course. And then after ETA 790 is approved, then they need to submit Form ETA 9142A at least 45 days prior to the first day of employment. So these are the things. A lot of time beneficiaries and employees, they don't know about these things. They don't need to know about this. I'm just giving, talking about all these things just to give you an idea. If you don't understand anything, that's okay. These are the things for the lawyers. The lawyer and employer, they will work together and they will take care of all these things. Last one is any other requested material for H2A contractors. This is kind of like a catch-all kind of situation. In every application, every petition, we need to submit a lot of supporting documents and evidence. This is these I mentioned in this topic. Next slide, please. All right, second step, submit your Form I-129. Once your temporary labor certification is approved, then the next step is I-129. The employer may request more than one worker, but no more than the maximum number set by the temporary labor certification. Workers may be named or unnamed, but the employee must be named if they are. So these are the requirements when the application, when the petition must name the workers. Number one, they're present in the United States, not a national of an eligible country. I told you before that there's eligible countries, but there are a lot of people, they're not from eligible countries, but they can still get this visa. Number three, required to satisfy the job requirements as stated on the labor certificate. So they must satisfy all the requirements mentioned in the labor certificate. Next slide, please. Thank you. And this is the continuation of previous slide. By the way, the way I make this slides and things in a way that even if you have difficulty understanding my English, because English is not my first language, you can read these slides and you can understand this. That's why I make this slide so easy for you to read and understand. So the employer may hire workers who are not from eligible countries. In such case, USCIS recommends submitting separate petition for those employees. The employer will also need to do the following. Number one, provide the name of all of the prospective workers who are nationals of ineligible countries. Also attach proof showing that it is in the interest of United States to allow the prospective worker to enter the country as part of the H2A program. All it means is like we need to submit a letter claiming that bringing these employees from unlisted, not listed countries is beneficial to America. And, we can do that. It's very easy to do that. Next slide, please. All right. Third step, prospective employees apply for H2A visa or enters with H2A classification. So as I said, the people who are already in America, they don't need to follow this step because they're already in America. If you are in a country where you need to get a visa before coming to America, you have to face a visa interview, apply for visa in your local US embassy, get the visa and come to America. However, there are some countries you do not need to get a visa. You can directly come to America crossing border with just a H2A classification. It depends on your background. If you have any question, let us know. We'll answer your question for these steps. Next slide, please. Also, when you apply for visa, you need to apply with a valid passport, photograph, confirmation page of DS-160 form, receipt for the application fee, receipt of approved I-129. So these are the requirements of visa application. When you do it, all of this thing. And if you have question again, let us know. We'll help you. The employee can also enter through a border with H2A classification with an approved notice. It depends on the country. If you are from a country where you don't need visa, you can do it. Next slide, please. All right, thank you very much. That was our presentation for H2A. If any of you have any question about H2A, you can ask me now. You can send us email. We'll be happy to answer you.
Thank you so much, Mr. Mahajan, for that informative discussion. As usual, our dear audience members, if you have any question, please feel free to use the chat box, or you can just email us your queries. I will be starting off with a few questions that came in our emails previously. So for the first one, we have a question from Ms. Malabika Dashiti, and she asks, do I need to take the LSAT exam for admission to JD or LLM programs in the US? Or I can be admitted to a JD or LLM program with an LLB degree from Bangladesh?
So it depends on the school. Thank you very much for this question. So if you have a LLB degree from a foreign country like Bangladesh, you can definitely enroll into a JD program or LLM program. It depends on what you want. So for JD program, most likely you have to take a LSAT exam. However, there are some schools, they can still enroll you for JD program without a LLM since you have a foreign law degree. So I would advise you to find out law schools where you want to enroll and see their requirement. And if you have any questions, send an email to their admission team, they will answer you. However, for LLM program, in most cases, they will not require you for LSAT. You can directly get admitted to a LLM program. Again, the requirements depends on the school. So I advise you to contact the school where you want to get admitted, read their website. Pretty much everything is mentioned in their website. And then if you have any question, you can reach out to them. Another important information before I conclude answering your question is that law degree and legal license in America depends on the state. There is no federal license. I mean, there are some federal license, but you must have a state license first. So if you want to practice in New York and if you want to practice in California, these two different things has a totally different kind of calculation. So first, pick a state where you want to practice, and then you make your decision about JD, LLM, or anything. Because if you want to practice in California, your path to get American legal degree, get barred, and other thing is totally different from if you want to practice in New York. So the very first step is determine which state you are going to practice in, and then make all the decisions. Thank you.
Thank you, Mr. Mahajan, for that detailed answer. The other question Ms. Shiti had was, I want to know how to practice law in the US. How long might it take to pass the bar exam in the US?
Well, it's a very broad question, very vague kind of question. It's very hard for me to answer this way. How long it may take to pass the bar exam, it depends on you. A lot of people that pass the bar exam in their first chance. Like I'm very happy to say that I passed it with a one chance. But I also know a lot of people, it takes a second chance, third chance, even fourth time taking the exam to pass the bar exam. It depends on you. How long it takes to practice law, it again depends on you. Because before you start practicing, you have to meet certain requirement, and that depends on the state, that depends on many other factors. It's really hard for me to answer this way, but if you take an appointment from me, I'll be happy to help you.
The second question that we have comes from Mr. Shahid Hassan, and he asks, I entered the US with a B1, B2 visa. I have been undocumented for 50 days. If my wife and 2 children under 18 years old attend a B1, B2 interview at the US Embassy in Dhaka, could their visa interviews be affected by my undocumented status?
Yes, most likely yes. Since you were out of status for 50 days, even though it's a very short time, but definitely it may have a very negative impact on their application. There is no guarantee. They can still get the visa. It's the discretionary power of a visa officer, but in my opinion, most likely it will have a negative impact on their application.
Thank you, Mr. Mahajan, for that answer. Next up, we have a question from Mr. Kausar Rasul, and he's asking, I have a B1, B2 visa. If I apply for an E2 visa from Bangladesh and get a visa from the American consulate in Dhaka, how long will be the visa validity? I've heard conflicting information. Some say 3 months, some say 2 years. Can you please clarify the rules?
Well, both of these are true. 3 months is a period in which time you have to come to America. So let's say you apply for E2 visa, you get the visa, you have to come to America within 3 months. But the validity of the visa is for 2 years. So within these 2 years, you have to set up your business, make it up and running, start filing taxes, and after 2 years, you have to apply to renew your visa. In the visa renewal time, you have to show that your business is up and running, you are making enough profit to maintain your family, you're not a extra burden for American government, and only then they will renew your visa. So both of the information is true. One is for when you must come to America, and another one is for when you must renew your visa.
Thank you, Mr. Mahajan, for that response. Next up, we have a question from Ms. Mohsana Begum, and she's asking, my wife, a US citizen, applied for me under family immigration visa, but I was denied twice by the US Embassy in Dhaka. If I apply for an F1 visa now, will it negatively impact my visa chances, as I have 2 denials under family immigration?
Well, First, I need to know why they denied your visa, family-based application, because family-based application is very strong application. It's an immigrant intent application. And since your wife is a US citizen, this is her constitutional right to bring her spouse to America. So I have to see why they denied your application. In my understanding, I could be wrong, but my understanding is that there's a strong negative element in your profile. Only then they usually deny visa in this circumstance. So if you have that kind of red flag in your application, in your background, most likely you'll not get student visa either. But to make any comment, I need to know why they denied your application.
Thank you, Mr. Mahajan, for that answer. The last question we have from our emails comes from Mr. Abdullah Al-Hilal, and he's asking, my father is a US citizen, applied for me under a family immigration petition. Since my priority is not yet open, can I apply for an F1 visa? Is there a chance of visa rejection due to my family visa petition?
Yes, you can apply for your student visa. Of course, there's always a chance of getting rejected. That's a different topic. But just because you have a pending family-based application, that is not a ground for non-immigrant visa rejection. So short answer to your question, no. Even though it is pending, it has no negative impact on your F1 visa application.
Thank you, Mr. Mahajan, for that response. With that, we are done with all of the questions that came in our archives. A few of the audience members have left comments on our chat boxes. Thank you, everyone, for participating. And with that, we come to an end to our session for today. Audience members, please remember, from next week, we will have the live session on Mondays on this same time. Thank you so much, Mr. Mahajan, for giving us your precious time, and we hope you recover very soon.
Thank you very much. Yeah, I hope so. I need to recover soon. Thank you very much. And thank you, everybody, for watching video today.
Yes. Thank you so much, dear spectators. We will meet again next week. Thank you so much. Have a great day.
New York, often referred to as the global epicenter, is a vibrant and bustling city that never sleeps. It's a heaven for immigrants, warmly embracing people from all walks of life. following its branches in Washington, D.C., Atlanta, Los Angeles, and Dhaka. 𝐷𝐸 has expanded to its fifth location, now serving clients in the heart of New York's bustling Forest Hill Tower in Queens. With 7 attorneys and more than 100 law clerks and case managers, 𝐷𝐸 is one of America's largest immigration law firms. From us, you'll get all types of employment and family-based, asylum, refugee, and legal immigration-related services from any part of the world, including EB1, EB2 NIW, EB3. 𝐷𝐸 is your safe address for accurate and reliable immigration services in the shortest possible time. Contact the number shown on the screen today.